I'm still talking.
You're not going to read the ordinance today, you're just going to read the first paragraph?
Read the first paragraph and it will be published into the record as a reading.
Okay.
Okay, yes.
Well, as an intervener, two of us here are interveners to try to save you people from the mistake that you made in the beginning. I think we are entitled to the same copy that you have now.
They are going to email a copy to all of us that made copies?
Yes, yes. Everybody that we got an email address for will get this email to you. Anybody else that sends me an email says, I want a copy, they'll get a copy. I mean, that's the way we've done it with all of it up to this point. Anybody that wants it, all you gotta do is contact me and I'll get it right to you.
That answer your question, Jim?
May I ask a question about it? Is this going to be published in the paper that publishes the legal notices, the Herald Record?
How many pages is it?
I was going to,
It was my understanding from Mr. Tennant, yes, it was going to be published in the paper. Now, he did not say what paper.
That'll bankrupt the county.
Yep.
That's just what he told me. So,
I don't know that it has to all be printed, does it? Just notice that it's.
Just notice where you can find
will
it.
be available for the Herald Record?
That's all. That's all that has to be published is that the
What
first
I would
reading,
suggest
you don't have
is
to publish the whole thing.
the commission publish it in accordance with their legal counsel, what he says to do. He just told me it was going to be published. He knows, he's advised you over these many months. He knows how it should be published, so publish it accordance with what
So
he's
you're going to
doing.
write a check with Tim about how it gets published?
Right.
Okay.
But it will be available here and any website that will
And
want copies.
it's also now online, email also.
And we could possibly get a copy over in the library, maybe over in the Center Point Library or something too, there where people could look at it or something. Maybe get it out around the county a little more with the hard copy or something possible.
May I ask, or make one request? You said he was going to read the first paragraph.
Yeah.
Could I request that he at least read through the paragraph that says authority and purpose?
Where's that?
That should be the second paragraph.
Second page?
No,
First
the
page.
second paragraph. There's just
Second
one.
paragraph.
That gives you the legal authority for doing this. It should be so stated.
If I could, I would just like to hear that paragraph.
What do you want me to read?
Instead of just the first paragraph, the first two paragraphs.
That's two paragraphs.
Right.
That's what you want. Is it okay, Counselor, if I read this much?
Are you going to take any comments after you read that?
I don't know, are we?
That's your decision.
That's not my decision. Are we taking comments after I read this?
I mean, I would just say out of an abundance of caution, take the comments.
Okay. Are you ready for me to read now?
Yes, sir.
Thank you. Rogers County Floodplain Ordinance. An ordinance establishing a floodplain area and requiring all contractors, persons, partnerships, businesses, and corporations to obtain a permit for development and the construction, substantial improvement, or relocation of any building or structure, providing for certain minimum standards for construction within the floodplain area and setting forth special procedures for submission and approval of plans and establishing penalties for any person who fails to comply with the requirements or provisions of this ordinance. Authority and purpose. The provisions of this ordinance have been prepared with the intention of meeting the requirements of Section 60.3D of the National Flood Insurance Program, the National Floodplain Insurance Act of 1968, Public Law 91-152, amended by the Congress of the United States through the 15th February 1975, West Virginia Code 7-1-3B, 7-1-3M, and 7-1-3KK, and West Virginia Code 8A-4-2, 81-5-7, 8A-7-2. This ordinance is an establishment and regulation of a way as the same is contemplated in West Virginia Code 58-3-1. I'm done. First question. Do I have to time you, or are you going to be good?
You better.
Oh, boy. You better.
David Richardson was here at the last meeting, and he spoke in detail about West Virginia Code 58-3-1. This was the code that Equitable tried to use when they were suing Doddridge County. And Judge Sweeney reprimanded Equitable's counsel, told them it was a misquote of law, it was a misrepresentation of facts, and they could not use it. And that ruling was sent to each one of these commissioners. It was also sent to Mr. Montaro, and Donald Tennant was in the courtroom when Judge Sweeney ruled. If you put this sentence in here, you are setting yourselves up for whatever ruling you make. You can be sued, and your rulings can go straight to Judge Sweeney, and you are giving him the authorization to overrule anything you've done. He's already said that 58-3-1 has no place in your floodplain ordinance, because a way is not the same thing as a floodway. A way is a road, it is a path, it is a means that you travel over. It's one word, way. Floodway is also one word. It is not a way. And Judge Sweeney was very specific about that. If you set this in here, you are undoing everything that Judge Sweeney ruled on. And I totally do not understand why it's in here. We've all commented against it. Donald Tennant was in the courtroom when this was done. So I honestly do not know why you are deliberately setting yourselves up for litigation. You are deliberately putting a sentence in here that enables anybody to sue you. It does not belong. I don't know how else to say it. If you leave it in here, I guarantee you you're going to be sued. And I'm not just talking about all companies. Now, if you need to go back to Judge Sweeney and have him reissue or redefine or explain it to you again, then I suggest you do that. But it has no business, and I don't know how else to say it. And I said it in less than 5 minutes.
You
so.
did, and you said it at the last meeting.
I did, and I'll continue to say it
Thank you.
every time.
Thank
Okay?
you.
Have you voiced that to Mr. Tennant?
Yes.
I mean, or,
Repeatedly.
okay.
But he was present when it was done.
And the ruling was written by Judge Sweeney and signed by him. And we're prepared to go before Judge Sweeney again and have the ruling reinstated if necessary. Because I want you to understand that this ordinance is not for a gas company. This is for the protection of the people and the citizens of Doddridge County. Period.
I would hope that that's what it's for.
Well, you've got an opportunity to make it be that.
May I ask you a question?
Somebody had that, I'm sorry.
I was in the court when this was all discussed.
Excuse me.
Oh, I'm sorry.
No, I'm talking to you, come on. You know the rules, come up here. Please. Please, thank you.
I was in the courtroom when this was discussed, and there was pretty much probably a 45-minute discussion on this. EQT's lawyers, it was almost like they were grasping for straws to get this way, as opposed to floodway or whatever. it was really sad to watch, really sad. And Judge Sweeney, when he made his ruling, the amount of time that he spent explaining why he came up with what he came up with was actually pretty impressive. His ruling was to protect the citizens and the residents of this county. To me, for Mr. Tennant to put this in with completely ignoring what Sweeney's ruling was is really a slap in the face for the residents in this county. I mean, and like Joy said, it is setting the county up to be sued again. And I think, real caution needs to be exercised. And I applaud Joy for asking that the second paragraph be read. Thank you.
Thank you. Okay, Kip.
I'd like to ask this to Harry and anybody else here that could tell me, what do you lose by taking it out?
I have no idea.
There's a big objection to it. What do you lose by taking that out?
I hate to speculate because I'm not the attorney on the floodplain ordinance. If you take it out, then an aggrieved party would have to file some sort of writ directly to the Supreme Court.
You're assuming it was in there to begin with. It was never in there.
Right, no, I'm saying if it, right, yeah.
It was never in the original.
I don't know what the thinking behind it is. It could be, I think like in an assessor type situation, if someone doesn't like the ruling from the county commission, they're allowed to appeal to the circuit judge, Judge Sweeney. So it could be just creating a similar provision, since there are other avenues that people can appeal a decision of the commission to a circuit judge. Ultimately, though, that's a decision for the commission to decide how they want to do that. Do they want to leave an appeal to the circuit judge in there for everyone who feels aggrieved, or do they want to take that out? And it would create a more difficult way to appeal. So, but that's all speculation, and that's up to all of us to comment on, and eventually for the commission to decide how they want to proceed.
May I say one more thing? I promise it's the last thing.
Wait just 1 minute.
Okay.
There's a lady back here had her hand up.
Yeah, wouldn't it behoove you to find out exactly why it was put in there instead of speculating?
Well,
You as the lawyer and you as our floodplain coordinator?
It sounds as if we need a little more info possibly on
Well, I
that.
mean, 2 weeks ago,
I
the
thought
lawyer
that
was here telling you that. Were you not listening?
I don't think he was
I
here.
mean, our comments don't matter.
He wasn't here.
I
Well,
gotta
there are
say,
several
and I
comments
even
that
understand.
have been incorporated in here, and
Take it
yes, your comments do matter. Believe me, we wouldn't be here today.
Well, but
We're
I
still
mean,
talking about this thing if everybody's comments did not matter.
well, that was a very important comment that was brought up at the last meeting by Joy's lawyer. And, I can't believe that it is back there.
I would like to say that it was not in the original ordinance. It's only in this revision because someone submitted it as a comment. And that you can all take grabs as to who you think submitted that particular comment.
Okay.
I don't know that it belongs. I would also like to say that I think it's very unfair to Mr. Wellings. He is our floodplain administrator, and yet this revised ordinance came in an hour after the commission started. Mr. Wellings hadn't even had a chance to look at it, and yet it's being submitted as a first reading. That's disrespectful to him, and it's disrespectful to the commission. I just don't see it. I want to go on record with that too.
I did get a chance to review it before this. I didn't have a hard copy to present to you. So yes, I did get a chance to go over it myself, although I know the rest of the commission had not.
May I ask the counselor a question?
Well, yes, he don't have to answer it.
Well, I understand that, I understand the legal.
If you don't want to.
But here's, does the county commission has the authority to strike 58.3-1 out of the ordinance?
Yes.
Yes.
Good.
Yes.
That's all I want to know. The ball is in your court, play with it.
Well, my suggestion is before the commission strikes that out of the ordinance, we consult with our attorney, Mr. Tennant. That's my opinion.
I would say you go back and read Judge Sweeney's order,
We can do that.
of which all three of you have a copy that I hand-delivered with my comments here.
Yep, I have it. You have an opinion, voice? Now it's
I'd like
time.
to take it out.
Huh?
I'd like to take it out.
Right.
I would like to know what his reasoning is for including it. I'd like to hear both sides of the issue. We hire an attorney to advise us, and we should listen to him also. So that's my feel, is we hear both sides of the issue and then make a decision.
I feel that if taking it out is going to benefit the county, that's my position, take it out. But we did hire an attorney, and we have to listen to him to a certain extent, like we live in the area all the time. Yeah, thank you, Mr. Foster. Okay, yes.
Well, how come Mr. Tennant's not here? for
Well,
this reading?
I can't answer that, I don't.
He has a commissioners meeting himself in the higher county at 6 o'clock.
I kind of thought that's where he'd be, but I wasn't sure.
Will he be here for the next meeting?
Will he be here for the next meeting? Will he, Dan?
I have not asked him, I don't know, I'll ask him to find out.
Okay.
If all possible, I'll shoot right in here.
Because we'd all like to
Mr.
know why he insists on having that.
Mr. Wellings does more communicating with him than I do. He's taking care of this floodplain ordinance, and that's what we hired him to do, and he advises us what's happening. Somebody has to get it.
Somebody would have to tell me to come up here. The one question that I have is, I really don't know what Mr. Tannen's background is, but I'm kind of curious as to what his affiliations are as far as the oil and gas industry is concerned, as far as what his primary practice is. And even though Mr. Tennant was hired by the county commission as legal counsel for the county commission, you as our elected officials, I mean, to me, I feel that he is also answerable to the citizens of this county. You know, you guys, we elect you as our representatives, but it doesn't mean that we lose a stake in what's going on. So, and I agree with Tina, what she said. It would be nice to hear what Mr. Tennant's reasoning is behind this. And, you know, I haven't gotten a copy of the new revised ordinance, which I'm hoping I will get. And every time I get one of these, I print it out, go through it, look at the comments, and try to look at stuff that might be detrimental to the county. There's certain things that with the last readings or the last copies, there were certain things that really, really needed to be spelled out to protect the county and to protect the residents. And it seems like every time we get a revised one, there's always something else that's kind of slipped in that it was sort of assumed wasn't going to be there. And thanks. I just wanted that on the record.
Thank you for your concern. I will contact either Dan or myself will contact Mr. Tennant and see if he can be here at the next meeting, answer some questions for you.
When is the next meeting, sir?
May 6th, I believe, first Tuesday.
Sunday, Monday, May 6th.
May the 7th.
May 7th.
Another question.
Yes.
In my experience, it is very difficult to do revisions, okay? And I just wonder, is somebody controlling the revision so that when something gets revised and taken out, that in going through another version, they don't get slipped back in? She's making a very good point. And you have to have controlled copies and controlled revisions, and it can be a very tedious process to control for exactly the kind of thing that you don't want to see happen. Is that happening? Is anybody tracking these besides people who have grave invested interests? Okay.